So we have a great panel here to talk about parallel investigations involving the SEC, DOJ, PCAOB, et cetera. The list goes on and on. It's going to be moderated by Dan Hayes. Dan's a partner at Venable in Chicago. He previously served in the SEC Chicago Regional Office and most recently served as the Supervisory Trial Counsel in that office. Next we have Derek Cohen. Derek's a partner at Baker Botts in New York. At an earlier stage of his career, he served in the Justice Department for almost a decade, and most recently as the Deputy Chief of the Fraud Section. Kathleen McGovern's joining us today from the PCAOB, where she serves as Chief Litigation Counsel and has served in that role since May of 2024. She previously served in the U.S. Department of Justice as well, and was most recently the Senior Deputy Chief of the Fraud Section. Eric Phillips is here as well. Eric is now the Supervisory Trial Counsel at the SEC Chicago Regional Office, where he has served for almost 22 years. And his prior roles at the SEC included serving as a branch chief and as a senior trial counsel. And next we have John Rademacher. John's a managing director of investigations with Secretariat in Chicago. And earlier in his career, he worked as a principal at Charles River Associates and also as a director with KPMG. Dan, I'll let you take it from here.
Thanks, Jim. So why don't we jump right in? I think everybody here is mostly familiar with what parallel investigations are. Maybe many of you have been involved in some. But Eric, I'd like to start with you from the SEC, since you're our SEC representative. How do they start at the SEC? How does the SEC kind of get involved? Where do they initiate? What's the origin story for a parallel investigation?
Sure. Well, first, let me issue my standard disclaimer that I'm here in my capacity as a supervisory trial counsel in the Chicago office of the SEC, but my views don't necessarily reflect those of the commission, commissioners, or other staff of the SEC. In terms of how parallel investigations get started at the SEC, I'd say there are three main ways. First, we may get a referral, or we may get an indication that we should start an investigation at the same time as other regulators or other agencies. So for example, some member of the public might submit a tip, complaint, or referral into our public portal, and at the same time, that person or that company may also contact another agency or another regulator. So we'll get the information at the same time, decide to open an investigation at the SEC, and then another authority might open an investigation at the same time, and we'll realize that we both have open investigations into the same subject matter. The second main way that we'll have a parallel investigation start is that at the SEC, we'll have a matter and we'll decide that in addition to our own investigation, the subject matter of the investigation might be appropriate for another agency. So for example, if we have an investigation where we think that the conduct might interest the criminal authorities, we might make a referral to the U.S. Attorney's Office in the jurisdiction in which the possible misconduct occurred. And then third, conversely, another agency that has an investigation might decide that the subject matter is securities related and that we might have an interest in conducting an investigation as well. So that agency will refer the matter to us, and then we'll have parallel investigations.
All right, I want to stay with you for a second. From the SEC's perspective, do you like parallel investigations? I mean, what are the pros, the cons from the SEC side of being involved in a parallel investigation with another agency, whether it's DOJ, CFTC, or some other?
Sure. So in terms of the benefits to the SEC of having a parallel investigation, first of all, it could lead to a lot of efficiency on our end, and we want to conduct our investigations as efficiently as possible. So for example, in the course of our investigation, we may think we might be interested in talking to a witness, but it may turn out that if there's a parallel investigation going on and with the criminal authorities and the FBI has already talked to that witness, we may discover from what the FBI learned in its discussion, its interview with the witness, that the witness actually doesn't know very much, or the witness knows nothing about the subject matter of the investigation, then that would probably influence our decision as to whether to pursue that witness. And as everybody knows, on both sides, our side and the defense side, and a witness and their counsel side, setting up an interview or a testimony with the SEC is a time-consuming and resource-intensive endeavor, oftentimes on both sides. So if we are able to achieve efficiencies through joint investigations like that, that benefits us. Additionally, sometimes the existence of a joint or a parallel investigation will allow us to find evidence that we otherwise might not have been aware of. For example, another authority might have spoken to a witness who turns out to be very important but wasn't on our radar screen. So we want to have, in conducting our investigations and in making charging recommendations, we want to have as full of a picture of the evidence as possible, and the existence of parallel investigations might allow us to do that, might help us in getting the most full evidentiary picture that we can have. Additionally, from our perspective, a third benefit is that sometimes other authorities have tools available that we don't. For example, criminal authorities have the ability to execute search warrants. Sometimes they can do undercover or covert operations. FBI agents sometimes do knock and talks, where they knock on the door of somebody and with consent conduct interviews, and sometimes through parallel investigations we get access to that evidence using methods that aren't available to us at the SEC. At the same time, the SEC has a lot of expertise sometimes that we can share with other authorities, and that benefits other authorities. We have various divisions with a lot of expertise inside those divisions. We have a lot of expertise inside enforcement. So those are some of the ways where there's benefits to us and sometimes benefits to other agencies in terms of conducting parallel investigations. But it's important to remember that our investigations are conducted ultimately independently. We're not conducting joint investigations. Our investigation is for accomplishing the SEC's mission. So we're conducting our investigations independent of other bodies. We may be doing things in concert with them for efficiency purposes, but we want to make sure that everything we do reinforces the fact that we're conducting an independent investigation for our own purposes and to accomplish the SEC's mission. So that's one challenge, is just making sure that we reinforce in everything that we do that we are operating independently. And then a second challenge is sometimes there are timing concerns where we have a parallel investigation, but the other agency is not ready to bring their case, and we are either ready to bring our case or we feel like it's necessary to bring our case more quickly. Like, for example, where the SEC wants to freeze assets, if we're concerned that a prospective defendant is dissipating assets, we may want to move in quickly. We may have statute of limitations concerns that other agencies have. So then sometimes the timing in terms of when charging decisions are made don't line up with other agencies with whom we're conducting investigations in parallel. And that can create challenges both for us and for defendants if we initiate our action while another agency is still looking at that same conduct. Sometimes we'll file our action with the possibility, knowing that it's possible that we'll conduct discovery for a year, conduct motion practice for a year, then the case will get stayed if, for example, criminal authorities end up bringing an action during the pendency of our litigation. And then from a defendant's perspective, sometimes a defendant has to defend a case that the SEC brings, knowing that there's a parallel investigation and that there's a possibility that another agency will bring a case, but they don't know what's going to happen. And so that creates uncertainty for a defendant in one of our cases as to what to do with our case, whether to fight it, whether to settle. So it creates uncertainty.
And I'm going to ask Derek about that in a little bit. But Kathleen, you kind of present a unique perspective here. We don't often get to hear from the PCAOB at these things. I've been to a few of these, and we don't often get a representative from the PCAOB to kind of talk about these issues, and specifically with the parallel investigations. I was at the SEC for over 13 years, never worked with the PCAOB. Do you guys do parallel investigations?
Yes, and before I start, I just have to give my standard disclaimer as well, similar to Eric's, that I'm here in my capacity as Senior Litigation Counsel at the PCAOB. However, I am not sharing necessarily the views of the board itself. I'm sharing my own personal views. So, and Dan, just before I start, since you don't often hear from the PCAOB, just to kind of remind folks or educate them in terms of our jurisdiction and our mandate. So PCAOB, the Division of Enforcement Investigations, has the authority to investigate registered public accounting firms and associated persons for noncompliance with Sarbanes-Oxley Act, or the rules of the board and the rules of the SEC, along with other rules and professional standards of auditors and broker-dealers. So just to kind of set the stage for that.
Sure.
So to answer your question, yes, we do have the ability to conduct parallel investigations, and we do so. We have the ability to share information with the SEC, DOJ, other federal regulators, OCC, FDIC, and other state regulators as well, as enumerated in the Act. Coordination with the SEC is pretty much standard practice, and actually we're required to notify the SEC if we have an investigation that involves a violation of the securities laws. And just to kind of, expand on some of the things Eric said, just from a bigger perspective, parallel investigations make sense. Coming from DOJ, being in private practice now at the PCAOB, conserve resources, you can really focus on the appropriate targeted conduct, and I think it's you enable the regulators who are best suited to do it to actually focus on that conduct, and it's an area that I've been particularly focused on myself since I've been there.
What issues do you face at the PCAOB as you're considering or looking at the possibility of engaging with another agency in a parallel investigation?
So I think the biggest thing for the PCAOB coming on board is, and again, wearing my DOJ hat and working with Derek, most of the cases that we dealt with, that in securities fraud and accounting fraud case, the question always was, where were the auditors and the gatekeepers? And so as a prosecutor, you're always thinking, you always want to put your gatekeepers in a nice clean bucket. Obviously they were lied to. That's fantastic. It doesn't always end up that way. It's not always black and white. Yes, the gatekeepers could have been lied to, but there could have been other things, particularly when you look at auditors as what we do here. Were there red flags? Should they have asked other questions? Did they comply with certain standards? And I think that's kind of the biggest issue that I encounter. And I'm able to say to people, look, I have the experience, I've sat in your shoes, I understand what you're going through, and through trust, I won't mess up your case. So that's kind of the biggest issue that we deal with. Some of the other issues we deal with that Eric mentioned, it's always kind of the timing, covert versus overt investigations. I don't want to be sending out a request for information or a demand for information unless the investigation is already out there. I don't want to be sending a request to an accounting firm, tipping off a larger investigation. So always mindful of that. And those are kind of the big issues that I see and that we're dealing with.
Okay. Derek, to touch on something that Eric mentioned. All right, you're in your office, from the defense perspective, client comes in and says, I'm being investigated by, the SEC, CFTC, PCAOB, whatever it is, DOJ. What are your first thoughts? I mean, what are your concerns as defense counsel when you're facing you've got a client that's being investigated by multiple agencies?
Yeah, so, oftentimes you don't know that up front. It's sometimes you do. Sometimes you have a client call up and say, I've gotten an SEC request, I've gotten a grand jury subpoena, we've gotten calls, there's been knocks by FBI, but more often than not, it kicks off with a reach out by one agency and not necessarily the other. And I always take the approach that you've got to assume, particularly in areas where you're talking about accounting or things that are going to lend themselves to where there are going to be a number of constituent agencies that might be looking to be thinking about all of them. And so just because today you're only hearing from one agency doesn't mean that there isn't another agency lurking in the back or is going to come around. And I just know, from my own experience, I think the last 6 or 7 years of my time at DOJ, I don't think I had any cases that didn't have a parallel SEC, and that included, I prosecuted the BP oil spill. We had the SEC involved in that, and they brought securities charges. So you have to sort of assume that. So I always go, and you want to take a sort of defensive posture, right, and understand, well, what is it that we're confronting? Because oftentimes what I have found are that clients will take a reach and start going through their own kind of, right, it's a big deal, obviously, within a company, and the first interpretation isn't always right. It could be very detailed about something, and they think that it involves X policy or Y policy, and they want to engage and immediately describe why that's wrong, and then you learn that that's not really what the crux of the investigation is. So it's always sort of, okay, let's take a deep breath. Let's figure out what this is. Let's reach out to the government and see what it is that we're dealing with. And we have multiple folks, and I do know from my time on the other side doing parallel investigations, sometimes it's, there are human beings involved on both sides. So sometimes it's really working, everybody has their policies where there's separate investigations and so forth, but there have been teams of folks that I dealt with when I was a prosecutor at the SEC that we worked on a number of cases together. We had a high degree of trust. There was a lot of coordination. There was a lot of back and forth. And there were times that we'd see, or that Kathleen and I as supervisors at DOJ often dealt with, you have turf battles or folks that personalities that don't necessarily get along, and you don't want your client to feel the brunt of some dysfunction there. So you want to try to get right, this is a sophisticated crowd, so that nobody has to take notes on this. I want to understand the facts, right? Okay, let's figure out what the facts are. I want to engage with the government. I want to figure out, who am I dealing with here? How are they dealing together? And how am I going to be thinking down, a couple, I want to be thinking a couple moves down the board on this, because I know I'm going to start to get requests for documents. Folks are going to have different things, and no agency wants to feel like they're getting short shrift. So I think the challenge of this is, particularly when you're dealing with clients who, hopefully are not often getting these kind of requests from the government. They're nervous. They want to get a quick resolution. The first instinct is, we've done nothing wrong, or let's get in front of them. And sometimes that's right, but often that's not the right move. And so there's no one playbook for this, but you do need to know where the pitfalls lie so that you can sort of set up a protocol at the beginning and start with communication so that it can go as smoothly as possible.
What kind of things can you do to try to find out if let's say the client comes in and it says, I've got this SEC subpoena, you learn the facts, and what are there things that you can do to try to find out if there's other government agencies involved? Predominantly, I would suspect DOJ. Yeah,
I mean, listen, sometimes they'll tell you. It's been my experience that DOJ tends to be a little bit more forthcoming on information, right? There are standards of, are we subjects, are we targets? SEC doesn't have that parlance. I think that just culturally, it's been my experience that it's much more sort of closer to the vest with the SEC. But there have also been times where the SEC might only be visible, the only visible agency, and they want to start taking informal interviews. And I say, listen, I need to know whether there's an AUSA I need to talk to, because I would like to have my bar license for a few more years, and I'm not going to bring somebody in to start talking and then find out that the FBI was sitting next door, and now I've got a whole other problem. So there are ways you can sort of force the issue a little bit. But I also find that like anything else, if you build up credibility and you build up, if I can understand what it is that you're concerned about, you're the SEC, and I can gather from your subpoena, right? The first thing of almost every call is, hey, can we narrow this? I need more time. What are you looking at? Can I figure this out? And depending on what it is, if it's an accounting issue or something, right, then you start to go to the resources that you have at the client. This is what we think we're looking at. What are the issues here? But now I'm starting to think, okay, where else could this lead? Now maybe I'm thinking I might want to do something reviewed under privilege. I want to get an outside auditor to come in, not the normal folks looking at it, because I want to maintain privilege and I want somebody working for me to be able to give it to me straight so that I have the credibility. And then sometimes, sometimes you have an issue, or oftentimes you have maybe not quite the issue that they think you do, but maybe some variation of it. And so, once you start to see that having been on that side, I think everybody who's worked as a regulator or prosecutor has had the experience of somebody pledging complete cooperation and so forth, and feel like you're just getting jerked around. So I try not to do that. Right? I say, listen, I got to run this down. I'm going to try to get you what I can. The more you tell me, the more I can narrow it and try to keep credibility. And then over time, you find that people tend to be a little bit more forthright when they feel like you're being forthright with them.
Can I just add, Derek? I love that you said that around bringing in a firm to look at the accounting data, because we have seen instances where in responding to requests for data, that transactional accounting data that's been provided is sent to the government without understanding the context of the data, particularly if it's coming from a homegrown system or it's an industry that maybe the government doesn't understand the lingo necessarily. So providing context, whether it be through a cover letter or even verbal calls to discuss, here's what's being provided, and an independent analysis that has some sort of risk assessment of what that data is, so you know just exactly what you're providing.
Well, and so you raise a good point. I mean, obviously, John and Derek alluded to this. You guys, from the accounting side, forensic accounting side, you guys sometimes get brought in to assist the lawyers or their clients in gathering information, synthesizing the information. What is your number one concern? So like when you guys are brought in and you understand that the client needs to respond, the lawyers have to respond to a request for information, a subpoena or whatever, turn over a bunch of stuff to the government, and you've got multiple agencies involved, what are your concerns from the forensic accounting side?
Right, with multiple agencies, it's maintaining the credibility of the investigation. I think the comment was made at one of the earlier panels that going through the Wells process, having sit-downs with the SEC, they appreciate a detailed presentation of the findings. I want to make sure that when we get into those discussions that we've done a credible investigation, that it's thorough, that it's unbiased. So really working with forensic accountants that have presented before the DOJ, SEC, that understand the level of scrutiny that's going to be involved in those types of discussions. So that's going to include making sure that there's a comprehensive approach to addressing the allegations, but that the approach is also agile to new information. As of course, you know, as you talk to witnesses, as you look at data, government may ask a question that makes you view the allegations in a different lens, that you're adapting to that new information and have a thorough investigation. A couple things I think you can do to demonstrate that as well. Things like rapidly preserving data is part of the investigation, and not just emails, right? But frequently we're talking about third-party applications, internal collaboration sites, Teams, WhatsApp, making sure that that data is preserved to demonstrate that you took the allegation seriously, you responded quickly to lock down data, shows that you have a thorough and comprehensive approach.
In situations where the client is a public company, may have outside auditors, what from your perspective, kind of what are the concerns in dealing with the outside auditors when you're gathering information, organizing it, synthesizing it, putting a fence around it, but you know it's going to be packaged up and sent to the government?
Right, so I think anytime you're dealing with multiple regulators, it's going to be a bit of a juggling act between what information you provide to them, what the communication strategy is, and I think that becomes even increasingly difficult once the external auditors get involved. But they do have some professional responsibilities to assess illegal acts. They need to consider whether the likelihood of an illegal act occurred, and if it did, what's the impact to their audit. Naturally, they're going to be concerned about any potential allegations around misstatements to the financial statements or internal controls. The one that frequently causes issues is around management integrity, right? So during their audit procedures, they're going to be taking representations from management, things like, are you aware of any actual or suspected fraud or misconduct? And if they are taking representations from management and there's concerns around integrity, they may need to adjust their audit procedures. Oftentimes it triggers what they'll call a shadow investigation. Essentially, it's going to be the audit team and their forensic specialists parallel review of the investigation team to determine if they can rely on the investigation findings. So they'll look at things like, is the investigation team independent and qualified? They'll look at the scope, the procedures and the methodology, and ultimately the findings as well. There can be a bit of a tension there with what is under attorney-client privilege. So usually we're working very closely with outside counsel to determine what it is that we want to present to them to make sure they're comfortable with the scope and the procedures performed. They may ask for things like the keywords that we applied to document review. They may ask for the sample of transactions that we reviewed. Ultimately, they're trying to get comfortable that the investigation, the accounting review, has been robust enough that it can help them determine whether or not they can rely on the findings.
Just to that point, if you have a public company and it winds up looking like it could be something serious like that, it's not uncommon that the audit committee will want their own counsel and their own investigation, and then when you now are the defense counsel to the company, it's almost like you've got another investigator involved by virtue of the audit committee that's going to be interacting with the auditors. So I think there's a distinction between sort of pulling together the information. So if you think about the outside forensic auditor to the company's counsel in response, sort of job one often with me is, okay, make me understand this, because I do this, enough to be dangerous, but I'm not an expert in accounting, and I need experts to tell me, whether there's something there. There's the gathering and sort of synthesizing of the information, and then there's what can often be kind of the advocacy piece that comes out of it. Like, here's what we find from it that make them. But you've got to be thinking about this, and this is where privilege issues come in. You've got to be careful with what you're going to do and how you're going to be dealing with this ultimately, because you might take care of one issue and then buy another issue. So you create something that says, okay, we didn't commit a crime, but we were really sloppy. Well, now that if not taken completely carefully, you may have created a situation where there's some deck out there that some securities class counsel is going to have. And so now you've got through the fire of the DOJ and maybe the SEC, but now all of a sudden you may have accounting issues that come up with your internal controls, but you also may have an active plaintiff's bar, and now that's another problem for you. So there's all of these pieces that you just need to be thinking about, and it's not, I couldn't tell you today every iteration of what can happen, but you at least need to know that those issues are out there, so that somebody's thinking about them and taking steps along the way to protect the companies, not just on the issue that's confronting you today, but what might happen a year from now.
And Dan, I'll just jump in, and John and I were talking a little bit about this, and this isn't from my PCAOB hat. I'm trying to think of which hat it is, but in terms of communications with the external auditors, I think coming from private practice, you sometimes assume that, all the communications, once there's an internal investigation starts, that it'll be privileged, and particularly in that regard, it's not. And so I think folks just have to be mindful of that. The other thing that, when John was talking about collecting the electronic communications, just to keep in mind that different agencies have different expectations and requirements as to how long you would keep that information and on what medium. So I think that's always something, and as Derek was saying, agencies do things differently, have different expectations, and you constantly have to manage that depending on who's looking and who's conducting the investigation.
Yeah, good point.
I think particularly where, when it comes to the auditors, we've had investigations where around fictitious revenues, and the accounting analysis of the revenues seems like they were accounting for revenue appropriately, but where the auditors had questions of what has the communications been like discussing auditor requests, which comes into Teams chats and Slack and that things like, they want to know whether or not the individuals providing them information have provided them inaccurate information. They want to make sure there's not an integrity issue there as well.
Yeah. Derek, so your client comes in and is, you figured out that there's a DOJ component, there's a criminal component, and he's got regulatory agencies investigating him, and you find out there may be other people being investigated as part of this. Do you try to find out who they are? Do you try to, what are your considerations in reaching out to them or their co-counsel?
So you're talking about whether I'm representing an individual?
Yes.
Okay, well, yeah, if I'm representing an individual, then I would definitely want to talk to the other lawyers that are representing individuals, because there might be good opportunities for joint defense and the ability to sort of share intelligence in a way that's useful for everybody, for sure.
Are you worried at all about the criminal aspect, DOJ, in talking to other witnesses that may be under this DOJ scope?
I mean, I wouldn't necessarily be talking to the witnesses, I'd be talking to their lawyers.
Yeah.
Right, so I'm going to be cognizant of that, and it's a relatively, even in New York where I primarily practice, it's a relatively small world. So if I don't know that lawyer personally, we know 100 people in common, I'm sure, and again, you can speak to people and professionals know how to do it ethically.
Does your calculus change if it's a company?
Well, if it's a company, usually what I'm more concerned about then is, do I need to start getting counsel for my employees, right? That's a more difficult thing, right? And this is one of these things where it's sort of like, I try to balance, I try to put myself in the position of my client. It's easy for me to come in and say, okay, listen, you're going to start paying for 50 lawyers, and we're going to hire forensic accountants, and we're going to do all, but that's not really what they want. If I say we need to do that, we're going to really need to do that. And it's not going to be my first instinct. But you do have obligations. There are ethical obligations to make sure that folks get, and oftentimes there are requirements from corporate agreements and so forth where you're going to have to indemnify individuals. And frankly, it's usually in the company's interest to make sure that they have sophisticated counsel representing them. So that's one of the issues there. And then, there's a lot then that goes into that. And, there is a push. And I can't pretend to have any idea of what the future holds for this Justice Department. We're in kind of unusual times, but there does seem to be a thrust of looking for individual culpability and so forth. And the idea whenever there's been anything out from the SEC or DOJ, there is this idea of, okay, if you're going to cooperate as a company, that means you're going to serve people up. And that makes it somewhat difficult for your employees to trust you, for you to go and say, okay, we're going to get you good counsel that are going to watch out for you if they think that they're going to be scapegoated. So it's a double-edged sword. I understand why the government wants to do it. I wanted to do it at times when I was a prosecutor, right? Companies don't commit crimes, the people there do. And you want to hold people accountable, but it can be a very difficult dance.
So, and I want to get your perspective on this afterwards, Derek, as well. But Eric, from your perspective, from the SEC's perspective, You've got parallel investigations. Everybody knows there, you know, it's a parallel investigate. There's parallel investigations going on. What's the SEC? What's your perspective about joint interviews and joint testimonies? You know, does the SEC, because of the efficiency purpose of it, you know, what benefit do they get from these joint interviews, say with DOJ, or and does the SEC ever do joint testimonies with another agency? And what are the kind of the disadvantages of joint interviews?
So I'll address interviews first. Sometimes it does make sense from an efficiency perspective to conduct joint interviews with other authorities if we're going to ask the same questions and cover the same ground as the other authority. Then from an efficiency perspective for us, for the other agencies, and of course for the witness and their counsel, it makes much more sense to do an interview jointly. Sometimes a joint interview can also make sense from an evidentiary perspective to limit the number of times that a witness is talking to the authorities. The more times the witness tells the same story, the more times there are inevitably going to be some discrepancies between those various times that the witness tells the story. So
that's one of those situations where it probably aligns for both sides, the defense and the government.
Right. In terms of sworn testimonies, though, we don't conduct those with other authorities. So sometimes from our perspective, in terms of the investigation and the importance of the witness, we decide that we don't want to conduct an off-the-record interview. We want to conduct an on-the-record testimony. And in that circumstance, it doesn't make sense to do something with other authorities. And so we take the person's testimony on the record, and that would just be an SEC proceeding without other authorities present.
Can defense counsel assume you're going to be sharing that testimony with the other agencies?
Well, we have various rules at the agency that the commission has promulgated about information sharing. And then the SEC staff, building upon those rules, has developed procedures for information sharing. And then when we talk to a witness, we give the witness and his or her counsel a copy of our Form 1662, which outlines all of those procedures. So it is, of course, a possibility that we will share information, but that's all consistent with the rules that the commission has issued and the procedures that we have.
If I say it's a near certainty, would that get you in trouble? You don't have to answer that.
I'll say it. Yes, of course they share.
All right. Kathleen, are there any limits to, like, what kind of information sharing can the PCAOB do? Are there limits on what you guys can share with other agencies?
Yes.
And there are limits on what you can get from other agencies.
Yeah. So generally speaking, the information that we can share are the engagement and client acceptance letters, the work papers, the backup for the financial statements, billing records, emails, communications, and the like. We can share information with the SEC, and we can share information and documents with other regulators as well, as long as the board, it's pursuant to the investigation and to protect investors. There are limitations. It depends on whether we have an informal investigation versus a formal investigation, of course, and I won't bore everybody with those details. We have similar limitations in terms of confidentiality and privilege, and we share information through access letters and agreements with those other agencies. I think one of the biggest limitations that I see is with the foreign investigations that we do of foreign regulators. There are cooperative agreements that the PCAOB has with foreign regulators. I think it's with 25 countries, including mainland China, and so there are very strict information sharing parameters that we have to engage in and go through before we then share foreign documents with a domestic regulator. And so that's kind of the biggest limitation.
Got it. So, John, you know as well as I think everybody in the room, that these investigations can take forever, years certainly. What are your primary, working with, companies and their counsel, what are the primary challenges that you face?
Well, one issue that I've seen, we touched on a bit earlier, is just not providing sufficient context to data that's being provided to the SEC and DOJ. So trying to get out in front of, trying to avoid any confusion or misinterpretation of the data by providing that context up front. We had a matter recently, it was an antitrust investigation in which information that was requested 5 or 6 years of transactional data, and that information was produced to the government. And it was clear based on follow-up questions that there was a potential that there was a misunderstanding of what the data represented. Okay, so providing sufficient context around how the data was generated, providing some context around what the different fields represent, and providing some analysis of the data to explain what it is goes a long way in avoiding any sort of misinterpretation.
Do you find it challenging? I mean, do you see this issue as whereas lawyers and maybe the clients want to get stuff to the government as quickly as possible, and maybe before you guys are ready to, before you would prefer to?
I think that's exactly it, because, and you don't know what's in the data, right? It looks like a straightforward request. Here's 5 years of data, but there's some risk in providing that information before you know what is in there. And providing some context, they obviously need to balance the need of responding to that request and getting them the information that they're asking for, but also providing context will be helpful.
Do you ever find it helpful? I mean, is it helpful in your experience to when it's to make an offer kind of with the production of data, especially when you're talking about voluminous, complex financial data or whatever it is, and say, we can explain this to you?
Right. So we worked with counsel to talk about options. Oftentimes we would get on a call and explain to the government what's being provided, cover letter or report, to put the context around it.
Got it. All right, we've got a few minutes left. I want to just, each of you briefly, just kind of get your final thoughts, recommendations, things, tips that you would have for the audience that we haven't discussed. I'll start with you, Derek.
Tips. I think overall, in this environment, there is going to be at least some temptation to feel like the cop's not on the beat, and I think that where companies make decisions today, thinking maybe that doesn't have the scrutiny that it may have in a couple of years, and they may regret it. I think there was when they changed the FCPA, my partner Brendan, who was originally supposed to be on the panel, and I put out an article that had the title, "Yeah, bribery is still illegal," right? And it is, right? And so I would just say, if I were an in-house person, and it's tough to be in-house because you have business people that want yes, 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 and oftentimes when you're in-house, you have to be the person to say no. I wouldn't change my practices just because the regulatory framework seems like it may be a little looser now, because things change and priorities change, and you may live to regret it.
Kathleen?
And Dan, I think I would just add to Derek's thoughts, and just, I think as you approach an investigation, just don't cabinet into, one regulator or certain conduct. I would just, one of the things I'll point out is, even with the PCAOB, under the Act, we're allowed to seek information and documents from more than just auditing firms and associated persons. So again, just kind of be expansive as you're sitting on the other side, thinking, who might be looking at the conduct.
Okay. Eric, any thoughts on?
Just building on something that Derek said earlier, that defense counsel should be proactive when they're aware of a parallel investigation. So for example, if the defense counsel is aware that two agencies, the SEC and another agency, are looking to talk to their client, the defense counsel might reach out proactively and suggest a joint interview, and that's something that we might agree to, might not, but it doesn't hurt to ask and to actually make that suggestion on behalf of your client. And then the second advice I would give is consider cooperation Again, cooperation in terms of cooperation credit at the SEC is going beyond the norm, but one of the factors that the SEC considers in awarding cooperation credit is cooperation with the SEC and other law enforcement authorities.
John?
For me, it's maintaining credibility of the investigation, making sure there's a comprehensive approach from a forensic accounting perspective, rapidly preserving data, making sure that when our investigation is scrutinized, that it's going to come off as credible, unbiased, and thorough.